In this video, we will learn vocabulary on the topic of administrative law. So let's get started. This glossary is intended as a general guide and is not presumed to be exhaustive. Adjudication. Agency determinations outside of the rulemaking process that aim to resolve disputes between either agencies and private parties or between two private parties. The adjudication process results in the issuance of an adjudicative order, which serves to settle the dispute and, in some cases, may set agency policy. Administrative law. The laws, executive documents, and judicial decisions that concern the operation of government agencies as well as the regulations and decisions issued by such agencies. Administrative law judge. The presiding judge in a federal administrative hearing. An ALJ serves as both the judge and the jury in an administrative hearing. Similar to the role of a judge in a civil bench trial. Administrative Procedure Act. A federal law passed in 1946 establishing uniform procedures for federal agencies to propose and issue regulations. Advance Notice of Proposed Rulemaking. A preliminary version of a prospective federal agency regulation. Codified. A term used to describe the process of converting a proposed rule or regulation into law. Rules are codified through inclusion in a legal code. A government's official record of laws. Comment period. The process in which members of the public can submit written feedback to a federal agency regarding a proposed rule. Due process. A citizen's fair treatment within the rules of a government's legal system. Enabling statute. Legislation that confers new powers on an entity or permits something that was previously prohibited or not allowed. In the context of administrative law, an enabling statute establishes the powers and responsibilities of a government agency. Executive order. A formal command handed down from the President to federal agencies within the executive branch. Guidance. Used to describe a variety of documents created by administrative agencies to explain, interpret, or advise interested parties about rules, statutes, and procedures. Judicial review. The power to interpret the laws and overturn any law or government action inconsistent with the United States Constitution. Regulatory capture. A situation in which a regulated entity or industry exerts a strong influence over the government bodies or officials tasked with regulating that entity or industry. Regulatory impact assessment. A document created before a new government regulation is introduced. Rent seeking. The practice of an individual or organization seeking an economic benefit through politics and public policy. Retrospective regulatory review. Processes used by regulatory agencies, as well as the President, Congress, state executives, and state legislatures, to determine if existing regulations should be retained, modified, or repealed. Separations of powers. A system of government that distributes the powers and functions of government among separate and independent entities. The separation of powers is sometimes referred to as a system of checks and balances because the Constitution provides each branch with certain powers over the other two branches. Substantive law. Substantive law is a body of law concerning rights and duties. Procedural law. Procedural law means a body of law specifying the procedures to enforce rights and duties. Sunset provision. A statute or provision of a statute establishing a date on which an agency, law or benefit will expire without specific legislative action.